From the daily list, item number 1 to 6.
My lord, item number 1 to 6 are connected matters, my lord.
Yes.
In all these 6 matters, my lord, there are private respondents. And service on 5 of the items, my lord, has been affected. But in item number 3, my lord, would not be affected because the private respondent was transferred to some other department. Presently, we have procured the
answers.
Yes, we have taken the steps, so I pray for 2 weeks' time, my lord.
Yes. Now, what is on the merits? What do you say?
My lord?
On merits.
On merits, my lord, this is a case. One of the ground is that ad hoc appointees have been replaced by another ad hoc appointees, my lord.
Ad hoc appointees have been
Replaced by
I think one case is compassionate appointment, is it not?
2 cases.
Two cases is compassionate appointment. Yes.
My lord.
And all of them have been appointed
But you
temporarily.
are employed only for a period of 59 days.
My lord, yes. But through various times, my lord, my service has been extended, my lord.
With break in service.
Yes, my lord. However, it's so happened, my lord, in the year to
Break in service.
my lord. It's so happened, my lord, in the year to
What is the break in service?
3 days break. In
3 days
every extension was made with 3 days break.
So it is an artificial break, not due to the fault of an employee.
No, it is not due to the fault of the employee, definitely.
The period will have to be taken into account as a continuous one.
But nonetheless, Your Lordship, they are all temporary appointees, Your Lordship, and they have not come through the normal procedure of selection. They were just appointed by...
According to you, it's a backdoor entry.
Yes, Your
my
Lordship.
lord, yes.
So you are trying to rely upon the judgment of Uma Devi.
Uma Devi, Your Lordship.
Uma Devi case is as early as in 2006.
Correct.
You are appointed in 2013.
Yes, Your Lordship.
So when the state has given a go-by to Uma Devi's case in 2013, why should they be penalized?
No, Your Lordship, this was also done by an authority which was not competing. The competent authority is the Director of Health Services, but here it was done in the district level.
See, that is right, madam. The problem is they are all class 4 employees.
Correct, Your Lordship.
Divesting of the duties by giving an artificial break itself is bad. There is a judgment of Justice Satyadev of Madras High Court. As early as you can see the judgment.
Okay.
1986, Tamil Nadu Law Notes Journal, page 153. Take the judgment. The Supreme Court, the Madras High Court says, you take action against the person who appointed them. Don't displace the class 4 employees.
We'll
That is the
check that.
judgment.
We'll examine that.
Then insofar as a compassion appointment is concerned, how can be a temporary compassion appointment? You can't say you become all right. Once compassion appointment, I think one lady passed away, son or daughter has come before this court.
That is what is written in the orders, Your Lordship. It was given the appointment that they are temporarily appointed on compassionate grounds for a period of 3 months. And they were
See, it is a dubious method to get rid of
class 4 employees.
class 4 employees, which is not correct.
Your Lordship, let the
You are the contesting respondent.
I am for respondents 1 to 4, the state respondents, Your Lordship.
I think I have rendered about 2 or 3 judgments on this issue at Madras.
My lord.
We will be having it.
I'll go through that.
Whenever a judge comes from other state, you must ensure that you read the judgment.
My lord, my lord, my lord. I have done few judgments, my lord.
1986.
See, madam, you please, see, now, how long there is a break? How long, is there a delay in, not without the filing of an appeal and approaching the court? Was there any delay?
No, my lord.
No delay.
No, my lord.
Why don't you accommodate them without back wages?
I'll
Give
have,
them employment because the services of class 4 employees are required. Why don't you give them employment without
appointments
back
have,
wages?
Your Lordship, I humbly submit that the appointments in these positions have already been made by the candidates recommended by the District Selection Committee now, Your Lordship.
That is right. Unless you say that there's a malefied or tainted, like yesterday some cases came up.
My lord.
How can the class 4 employees be penalized? Please see the judgment. 1986 Tamil Nadu TNLJ, page 153. the judgment starts on the right hand side, the relevant portion will be on the left hand side bottom.
Your Lordship. We'll examine that, Your Lordship.
2 weeks time, you also get prepared.
My lord, yes.
Don't ask my PA who has come from Madras. You ascertain or you check from the site.
My lord,
1
yes.
to 6, Your Lordship.
Deeply obliged.
Item number 7.
You also get instruction from your client
My lord,
whether they are willing to give up back wages.
my lord.
Similarly, you can also get instructions to give a quietus to the matter. Without back wages, they can be employed.
Right.
Suppose we agree with his case, then you will have to give them back wages. So unnecessary, without any work, you will be paying money. Of course, we are entitled to moral relief. But still, if it is a question of settlement, then it will be a quietus to the matter.
My lord.
And any settlement cannot be treated as a precedent.
No.
If we render a judgment, it will be a precedent.
No.
You ascertain.
We'll seek instructions, Your Lordship,
2
accordingly.
weeks
Deeply
Right, Your
obliged.
Lord.
on any Monday, Tuesday, Wednesday, Thursday. Any Tuesday, Wednesday, Thursday.
Item number 7.
May it please your lordship. In fact, I'm here against the judgment or against the order passed by the Learned Single Judge, wherein a writ petition filed by the respondent number 1 was entertained and an interim order at page 16, that is Annexure A, was passed. Now the issue here, your lordship, is that consequence to a division bench order of this honorable court, that is on 9/6/2023, wherein the division bench of this court has directed me to file a civil suit. I have obeyed the order of the division bench. A civil suit was filed, and there is an order of the civil court saying that anything to be done within the suit land, it has to be with the permission of the plaintiff, that is the appellant herein. Now, I am aggrieved by this second writ petition filed by the respondent number 1. That is a Dorbarshnong, your lordship. Dorbarshnong is a village. It's a village council. But in Khasi, we call it Dorbarshnong. It is the lowest hierarchy of, we have got 3 hierarchy in the district council. We have got the district council, and at the intermediate level, we have got the chief, the same, and at the lowest level is the Dorbarshnong. Now, this Dorbarshnong, it is claiming to be owner of one plot of land, where they used to, on my permission, I used to allow holding of playground, footballs, play as a playground, etc., etc. This land originally belongs to my grandfather. Now, let me come and concentrate to the order passed by the Learned Single Judge. Your Lordship, by virtue of the order passed by the Learned Single Judge, the respondent number 1 had taken advantage by issuing permissions to hold trade fair. And for that reason, I have sought
It's only for public purpose.
it is
Only for public purpose. They are not taking
Lordship.
the land or usurping the land.
Lordship, I am the owner. If at all it needs to be done within the
There
land,
is a dispute. There is a dispute. Civil suit is pending.
agreed.
Whether the last daughter is entitled to benefit or not.
Lordship.
And then
Now the issue here, Your Lordship, is that the order which was passed by the division bench as well as by the civil court is in my favor, plaintiff. We do not say we will not allow it for public purpose, anything like that. Now, holding of trade fair, there is a commercial, it's a multi-crore enterprise.
I think you have come against the interim order, is it not?
Yes, Your Lordship.
Then
I've also, now, by means of this interim order, now the respondent have gone before the deputy commissioner and sought permission to hold a trade fair. This is a multi-crore enterprise. Holding a fair,
we will direct the civil, the court below to take up the sub-judge. Is it not? Subordinate district court. And the matter is pending, is it not?
civil court.
Civil court. So we ask the civil court to take up the matter and expedite it till such time. Let the status quo of granting permission and conducting trade fair continue. No prejudice is going to be caused.
Your Lordship,
Without an early disposal, we will say that without rendering any finding on the merits of the matter, we will direct the lower court to complete the matter at the earliest point of time. We will fix the outer time limit of 6 months and finish it.
Lordship.
Let them conduct.
we are in agreement with that because we are saying that they could not have filed a writ petition before this honorable court when the matter is sub judice in the civil court. That is our case, Your Lordship. Now, using the land for an activities which is of a high dimension, huge commercial dimension, that's not permissible, Your Lordship. Holding of odd fair, religious fair, some festival, we are allowed, we have no issue, Your Lordship, on that. But holding a commercial activity there, where there is a huge business interest, that I am against, Your Lordship. We are against it.
See, ultimately the revenue, it's for the learned single judge has said that is for a public purpose. That's what the learned single judge
Your
has said.
Lordship, revenue generate to whom? Whether to respondent, who is not the owner. They are not claiming to be owner.
We will also observe that in case you succeed, the revenue that is collected by them will be given to you.
Your Lordship, that will be very disastrous, because if at all the revenue is to be paid, let it be paid in the exchequer of the deputy commissioner or the exchequer of the civil court, because the civil court is subjudice with seized with the matter, Your Lordship. Under no yesterday, Your Lordship, I had filed an objection before the deputy commissioner highlighting the orders of this court, and the deputy commissioner said, "Oh, we didn't know about the order passed by the civil court. We didn't know." So now they are saying that they're going to stop the enterprise, but be that as it may, Your Lordship, presently, I'm seeking the indulgence of this court to stay the order of the learned single judge, and let anything to be done, it has to be before a civil court. If they want permission, let them go before a civil court, not to any other authority who is not party to the dispute, Your Lordship. That is my case, Your Lordship.
Lord, I am representing the Lamkra Dorbar, my Lord. If I can submit. My Lord, as far as the rights of the appellant herein is concerned, my Lord, that is yet to be established. The civil suit is pending before.
Who are you?
My Lord, I am the Lamkra Dorbar, my Lord. I am the Dorbar, my Lord.
Really?
I am the Dorbar with the village headman and the Dorbar.
The property doesn't belong to you.
My Lord. My Lord, as far as this property is concerned, my Lord, this property does not belong to the appellant, and this property originally belonged to one Uphan Lindo, who has already donated this land to Shillong municipality, my Lord.
Who already donated.
Already donated.
that's fine,
And
Lord.
entire facts
I will hear you.
has been suppressed by the appellant, my Lord, and then they filed a suit, and there also, my Lord, entire facts regarding that the land has already been donated has been suppressed. They have not even been made party.
That's the case before civil court, Your Lordship.
That is it. Let the civil court decide.
Yes, my Lord.
Till such time, let them utilize it.
So far,
You
utilization.
will get the benefit. No, sir. What is it?
Right.
No, right now,
Order is in which page? Order
at page 16, Your Lordship.
16, my Lord.
15.
16. The order is, does not say that allowing the respondent to use it. It does not say that. It just says that the order of the division bench has to be. Let me read, Your Lordship.
Operating part, paragraph 6, my Lord.
So let it be used as a playground and other purpose. Don't use it for commercial purpose.
Yes, Your
My
Lordship.
Lord,
That's my case.
This is the only place, my Lord, in that area where this odd fair and sometimes trade fair and all is been put in, my Lord. Now, there is no other place in the entire city, my Lord, where this such programs can be held.
That's
So
incorrect.
in such a scenario, my Lord, if such a restriction is put, my Lord, this will not be good in public interest, my Lord.
This is,
And even learned single judge, my Lord, in public interest.
there is
Given
already a
direction.
trade fair running in the city, Your
Paragraph 6,
Lordship.
my Lord.
Yes.
There is already a trade fair running in the city.
Page number 56, there is an order, 36, sorry. 36 is an order of the division bench in which my brother is also a party.
Yes, my Lord.
In para number 6, it has been stated that you can use it for a playground for a period of 2 years. Thereabout, the order passed by the learned single judge is also an interim in nature. Final order has not been passed. We'll request the learned single judge to decide the matter at the earliest point of time. And the pendency of the petition will not be a bar for the civil court to take up and decide the matter.
Yes, Your Lordship.
My lord.
Yes, Your Lordship.
So till such time, we'll give 6 months time. Till such time, don't use use it for trade fair.
My lord.
How the trade fair is going on?
My lord. No,
nothing is good.
No, my lord. No trade fair.
You wait for 6 months.
My lord, if I'm not wrong, my lord, permission was issued for conducting the trade fair. Now, my lord, even the,
When is it issued?
my lord, I do not have the details.
For which period?
Probably coming months, my lord.
April.
1 minute.
Now, even the law,
If the permission is granted, you conduct the trade fair only for that period. And after that, no permission till the civil suit is decided.
now if my lord will see, first of all, the appellant's right is yet to be established, my lord. If the land is not in their name.
We are asking the civil court to decide the matter.
My lord, may kindly, if my lord will give a direction just to the civil court to decide the matter, we have no issue. My lord, till such time, my lord, if any restriction is put, my lord, then it will be a problem in public interest.
Suppose he succeeds. Suppose he succeeds.
My lord,
The revenue that is collected, how are you going to account for it and give it to the person concerned?
my lord, in that regard, direction may be issued, but however, as far as the restriction is concerned, my lord,
So you are willing to, in case you succeed, you are willing to pay account and pay the money to the petitioner, appellant.
my lord, I'm appearing for the first day today, my lord. So if I get some time, my lord, I can have some necessary instruction, my lord, in this.
What is there, sir?
Lordship, may I?
We are going to say that in case, if you say, we'll record your statement, you are an officer of the court.
We cannot
We are not
trust
passing
any.
any adverse orders against you. In case he succeeds, the amount collected by you from another person is not correct. According to you, the land has been given to you as a gift.
The land has been given to the Shillong municipality, my lord.
Municipality?
Shillong municipality.
Not to them.
Yes.
Municipality has gift.
Yes,
In that, you are running a show.
my lord.
Trade fair.
My lord.
Correct. That's your, wait a minute, sir, that is his case. You can't prevent him from stating his case.
Yes, my lord. And entire facts, my lord, as regard to its donation, entire facts has been suppressed by the appellant, and they moved before the court without.
We will say whatever amount you have collected pursuant to orders of the Shillong, what is the society here?
Shillong municipal.
Shillong? Municipal Board. Municipal Board.
My lord, the land was donated to the Shillong municipal board.
A land which was donated.
Pursuant to the orders of the Deputy Commissioner, you are running the trade fair.
No. Even prior to that, my lord, we are the one from the very beginning, my lord. We have been in possession of the land, even though this land was donated
The
to
land
the
is in your favor.
My lord,
That's not correct, Your Lordship.
that is the truth, my lord.
Then in case he succeeds, you return the money, whatever is collected, you keep the account.
My
steady.
lord, that in that regard, my lord, may kindly.
That's the most dangerous part, Your
My
Lordship.
lord, he is not agreeing to it, my lord, because he wants to stop the
Your
entire
Lordship.
thing, my lord.
We will ask them to furnish the details of the account to the lower court. You will also get a copy of the record.
Lordship,
Then you,
I want to suggest, let us receiver appointed by the civil court
No, my lord.
collect the whatever proceeding.
What is it?
A receiver be appointed by the civil court. Let a receiver be appointed.
you go and pay there before the court. Why should he pass an order? Your writ appeal.
Yes, necessary application can be moved, my lord. There.
That
If you
objection.
are asking for some relief in the writ appeal, that has got to be granted by the civil court.
No, Your Lordship,
Their intervention application was rejected, my lord.
Lordship, let me draw Your Lordship's attention to page 85, which is the civil court order. 85. The relevant para is 23.
85.
Yes, Lordship.
Yes, sir.
Based on the observations made herein above, no ad interim injunction can be granted in favor of the plaintiff petitioner. However, considering the fact that the Honorable High Court of Meghalaya in writ appeal number so-and-so had directed both parties to maintain status quo, and the odd fare not exceeding 2 in a year may be allowed. The same, in the opinion of this court, should be with consideration for the plaintiff petitioner while granting such permission till disposal of the suit. This is in place, Your Lordship. Page 85, Your Lordship, is
When was this order passed?
this order passed on 9/11/2023. There's no appeal, no petition to rescind it or to alter it, nothing. Now they are The written statement also is yet to be filed by the respondent number 1 here. In the face of this order, Your Lordship,
Period 2 years, court has granted 2 years permission. Court has granted 2 years permission.
fair, or fair means not trade fair, Your
No, my lord, it
Lordship.
is
Or fair means
trade fair.
religious fair.
Huh?
Religious
Wrong
activities.
statement, my lord. Misleading.
Or fair is not a trade fair. It cannot be read
Absolutely
to be a
not.
commercial. And the,
Odd fair is not a.
no, or fair cannot be read as trade fair.
My lord, that is wrong statement, my lord.
What wrong? This division bench.
Even during the division bench, my lord, in the last case, my lord, they were having objections regarding trade fair, and that is why this order was passed, my lord.
We are not talking of trade fair, Your Lordship, or any commercial activities.
Permit them to have the playground. So they'll permit you to have the playground
Yes, my lord. My lord,
or not? We'll see.
my lord, if my lord will
In the face of
let the civil court, my lord, decide the establish their rights in the civil court, my lord, then we will have a right.
We'll direct the civil court to decide the matter. They have 6 months from ready to issue the order. And we'll direct the court to take up the matter weekly once.
Only in this aspect, my lord, that is okay.
No, entire civil
But
matter.
if, my lord, restriction is put in, my lord, that will be a problem, my
Not
lord.
required. Come. The present appeal has been filed. This coming up for admission or after admission?
This is in orders, my lord. I am appearing for the first day today, my lord. If my lord will grant me some time, my lord, I need instruction.
Already you've taken notice, is it not?
yes,
My lord, today I am appearing for the first day, my lord.
this
I have filed my vakalatnama on the last date as soon as this matter was fixed.
he was before this court and
I
and it
was there, but I informed the court that notice may be issued to the parties, my
there.
lord. I cannot appear without vakalatnama. On the same day, I obtained the vakalatnama and filed it, my lord.
You are the only contesting respondent.
My lord, state
Yes,
also is
Nominal
party.
state. We're a nominal party. As a state, we're a nominal party. It's a private dispute.
He is only a formal party.
Gotcha.
If my lord will see page number 39, my lord, that is the, if my lord will come to page number 39.
The writ petition has been filed by.
respondent.
The writ petition was filed by me, my lord. What has happened is, if my lord will come to
How
page
is the writ petition maintainable, sir?
Yes.
How is it maintainable? It's a private dispute. How is the writ petition maintainable?
my lord, if I can explain little bit about the case, my lord. If my lord will come to page number 39 of the writ appeal, my lord.
30?
39. If I will read out, my lord, this order little bit.
This is advised status quo. What is your prayer?
My lord, what has happened after this order, my lord, if I can explain.
What is your prayer in the writ petition?
Writ petition, my lord, prayer is page number 33, my lord.
30?
33. I just sought a direction, my lord.
1 minute.
Yes.
Affidavit. Where is the prayer? 33?
Page 33, Your Lordship.
33.
Paragraph 6, my lord, down, below person.
Who is 1 and 2? Who is the first respondent? Who is the second respondent? First respondent and second respondent.
Let the state, the superintendent of police and the deputy commissioner.
In fact, the writ petition, whether superintendent have been shown to represent the state, contrary to section 80.
Because of the denial of the permission, my lord, they were made party, my lord. It is because
Superintendent
of
of
their
police
report.
never
The-
represent the state.
The read appellant, my lord, herein, they have filed multiple of complaints before the authorities, my lord, to deny permission. Therefore, they have denied the permission.
Originally, they have denied permission, Deputy Commissioner.
Where have we challenged the denial of permission? Where have we challenged?
My lord.
Sir, you are seeking permission, sir.
Here, my lord, they have denied the permission and therefore,
They are entitled to deny or grant permission.
right, my lord.
When they have denied it, you should have challenged it. Where have we challenged? Where is the quash?
They have not issued any order for denial, my lord. They have not issued any order for denial. My lord, there is
You are
two
denied. You say there is no order of denial.
My lord, I can explain. The land, my lord, which is the suit property herein, my lord, there is two part of it, my lord. Now, as far as what has happened, as far as that writ petition is concerned, there is the Niyamkhasi people, my lord, those who are following indigenous faith. What they do is they perform the annual religious ceremonies, my lord. They perform in that ground and thereafter they start and take out the rally from there, my lord.
Yes.
Now, when we have applied the last time, my lord, the permission was granted by the Darbar. However, as per the order of the Deputy Commissioner, we have to obtain NOC from the Deputy Commissioner's office. When they have applied for the permission, my lord, that was denied on the ground that multiple complaints have been filed by the writ appellant herein, my lord. And on the ground that the civil suit is pending, they have denied the permission.
Where is that?
And therefore, my lord, the writ petition was filed, and what has happened, Deputy Commissioner has allowed to perform the ceremony in another adjacent area, whereas not in that area the ritual is performed. It is always the ground where the ritual starts, my lord. And therefore, petitioner had to come before the court.
So you are seeking a relief against a private party. How can a writ petition is maintainable, sir? Petition itself is not maintainable.
My lord, we have made the Deputy Commissioner party because they have denied the court.
Merely because you have made him a party doesn't mean that writ petition is maintainable. You must show that there is a right, or at least there is a statutory violation. Nothing has been shown.
Now, even the Honorable Division Bench order, my lord, it clearly stated that
But you should be given 2 years time to run the outfrap.
not 2 years, my lord, 2 times in a year, my lord. If my lord will see the order.
2 times in a year.
Yes,
Yes.
it was allowed. When it was allowed, my lord, even then, my lord, writ appellant, my lord, herein, failing to get the injunction from the trial court, my lord, they have filed multiple of complaints before the authorities, my lord, just to stall the entire programs, my lord, which is being held there, my lord.
I'm sorry, we are allowing the appeal and we are straight away dismissing the writ petition. Now we have filed the, against the interim order you have come, we are dismissing the writ petition on the ground that the writ petition itself is not maintainable.
Actually.
Come. The present appeal has been filed against the interim order of the learned single judge dated so and so. Wherein it has been held that the usage of the ground is in public interest and the interest of the community as a whole. And that without deserting the issue of title to the property, comma, the authority the decision, if any, for grant of permission is to be taken on its own appreciation on a case-to-case basis. The other single judge has also held that there should be no hindrance to use the ground and also for permission to be obtained for holding the odd fact, and directed the matter to be listed for hearing on 7th February 2024. Against the said order, the present appeal has been preferred. A reading of the pleadings of the parties would reveal that the property is situated at Fire Brigade so and so, which is known as Madan Liu so and so a path go, sir, in so and so ground. Earlier, a writ petition was filed, being 519 of 2022, against which, and ultimately it landed up before the division bench in writ appeal 5 of 2023. In the division bench, one of us who is a party to the proceedings has granted permission, pass the following order, which reads as follows. Which paragraph, sir? Para number 22. Full stop. The main contention of the writ petitioner who is a respondent herein, the odd fair permission that has been granted to be conducted twice a year is include the trade fair, and that the land has been purchased, land has been devolved upon the writ petitioner, and that a title suit is pending before so and so court in case number so and so. When the appellant herein has no right to the property in question, preventing the respondent writ petitioner in conducting the trade fair as directed by the court amounts to violation of the orders of the court. A cursory glance at the pleadings would make it very clear that civil suit is pending before District Council Court at Shillong, bearing TS number 30 of 2023, for declaration of right, title, interest, confirmation of possession, and permanent injunction, along with the miscellaneous application. Full stop. The matter is still pending adjudication. Still is pending adjudication. Is still pending for final adjudication. Full stop. The parties cannot try to approach this court invoking extraordinary jurisdiction of the court to decide the private issues when the suit is already pending. Stop. The prayer writ petition reveals that there is a private dispute for which relief has been sought for. Though the writ petitioner would contend that respondent 1 and 2 have the ultimate authority to take or grant permission, and that the writ petition is maintainable, in the present writ petition no relief has been sought for challenging the decision of the authorities, more so when no decision has been taken in the present case on hand. As stated supra, private issues cannot be resolved by exercising the extraordinary jurisdiction of this court. We are of the view that the writ petition itself is not maintainable. However, in order to give a quietus to the matter, we expect the so-and-so court, we expect the judge, District Council Court at Shillong,
Lordship, presiding officer, subordinate district.
that you give so-and-so to take up the case number so-and-so on day-to-day basis without adjourning the matter beyond 7 working days at any point of time, and bring the issue to the logical end within a period of 6 months from the date of register of the order.
Much.
The writ appeal is disposed of. Writ petition stands dismissed.
Obliged.
Much obliged. Good day, much.
So you call for the writ petition papers. If it is not listed, is it listed before the learned single judge?
Yes.
Today?
Not today.
Not today.
It's not there. So call for the writ petition paper, put it in the additional list today itself. Pass out.
Much obliged.
Now we can call. We can call. We can call and close the writ petition. See, both the writ appeal as well as the writ petitions are closed.
Item number 8.
On the you quote that on the judgment of the Supreme Court in Anti Mukta case, where how the writ petition can be private against a private party, when on what kind of situation writ petition is maintained.
Here the petitioner, my lord, is the writ appellant herein, my lord. He was working as a technical assistant, my lord, in the Department of Anatomy. Here I am challenging the order dated, there is a page number 24, my lord, impugn order,
Sir,
my lord. Page number 24.
24.
Yes, my lord. Oh, that is, my lord. My lord, I am sorry.
The Union of India,
My lord.
what instructions?
My lord, I have this.
To file an objections?
My lord, our affidavit that was filed before the learned single judge is on record, my lord. So
That will suffice.
that will suffice, my lord.
You ready?
My
You
lord.
ready?
If my lord will give me some 1 week time, my lord, that will be sufficient.
Yes. At the request of the appellant, post the matter, when the matter is taken up for hearing, the counsel appearing with the Union of India would submit that they have already filed an objection before the learned single judge. That would itself suffice
My lord.
for them to address argument in the present appeal. 1 week.
Obliged, ma'am.
Deep.
That's all. I think we were thinking of listing more matters. Yes.
Obliged.